Welcome once again to Lehto's Law. Here's Steve Lehto.
I had a whole bunch of people send me this article, and it involves the Institute for Justice. And here's a case where right now they have to take this thing up on appeal because the court has ruled against them. And I think most people who hear this are going to go, wait, what? So this was originally published in the Farm Journal, but it's been published in many, many places. But Chris Bennett wrote this version. Pennsylvania court rules against gun clubs in private property case. So people who own private property or entities that own private property, how much privacy can they expect on that property from government agents who come in and snoop around? So according to a Commonwealth Court decision in a case pitting the Pennsylvania Game Commission against two private gun clubs, the court has said it's unfettered. It's unfettered, the access or power the government has over private land. So the court ruled recently against two hunting clubs in their lawsuit accusing the Game Commission of private property rights violations. The Institute for Justice represents both of the clubs, and they will appeal this. In its ruling, the Commonwealth Court in Pennsylvania noted the government's absolute power to, quote, roam private land without consent, warrants, or probable cause, end quote. And so that's a scary concept. If you have a piece of property, and you might think, boy, I'm safe in my house here. But does that mean that government agents can wander the property? Private land isn't public property, says Josh Wyndham, an attorney with the IJ. That might seem obvious, but all too many officials at every level of government disagree. They think they have a blank check to invade private property. We'll see what the Pennsylvania Supreme Court has to say about that. So the story goes back to 2021 with the Pitch Pine and the Punxsutawney hunting clubs suing the Game Commission after game wardens consistently entered club lands without permission or warrant and secretly monitored club members, including photo collection via installation of hidden game cameras. So you hide a game camera on someone else's property, you come back later, you grab the card off it to see what you saw. The warden's behavior, according to the lawsuit, was a violation of Pennsylvania's state constitution, which explicitly protects persons, houses, papers, and possessions. And so the big question is that land that you own a possession of yours? Certainly not a person or a house or papers. And one of the things you have to look at when you look at a list like that in the Constitution, whether it's a state or the U.S. Constitution, is quite often they'll put a string of things in there, and you look at it and go, they're clearly not just saying it's these things. They're trying to do it kind of broadly. But your house is your house, but your papers? You know, is that legal documents? Is that a manuscript for the novel you hope to write someday? What are your papers? You know, and your person, obviously, you know, we know what that is. So most Americans assume law enforcement must obtain a warrant to enter or surveil private land. But for roughly a century, the open fields doctrine has allowed government officials at state and federal levels unqualified access to private land. And the open fields doctrine, of course, came from the Supreme Court. So to overcome that, you either need the Supreme Court to overturn itself or modify that ruling, or you need a protection from a state constitution, which is not as broad as the U.S. Constitution on this topic. So in its judgment, the Commonwealth Court detailed the alarming powers and unfettered discretion assumed by government. The facts of this case are not in dispute. This is the court writing. The hunting clubs are member-owned hunting clubs that own thousands of acres of private land in Clearfield County. Members use the properties to hunt, vacation, and enjoy nature. To ensure their members' privacy, the hunting clubs have posted their properties with no trespassing signs and have installed gates at all entrances to exclude non-members and intruders. However, the entry statutes empowered game wardens with unfettered discretion to enter upon and roam private land without consent, warrants, or probable cause. So they're basically saying that they don't need any reason. They don't need any suspicion. They don't even need a hunch. A game warden can wake up one morning and go, I'm going to go for a walk on that property because I feel like it. I've got unfettered rights to do so. In ruling against the two hunting clubs, the Commonwealth Court was bound by precedent set in a case back in 2007 called Pennsylvania versus Rousseau, when the Pennsylvania Supreme Court said possessions do not include private land. So that, to me, is the kind of thing where you have to stop that and look at it and go, wait a second. Of the things I own, okay? I've jokingly told you before, this right here, it's on my desk. I own that. That's mine, okay? Now, I know what it's worth. It's not priceless, but it is, in fact, mine. I own this, okay? So if you come around and you see this, and you go, I'm going to take that. You're stealing from me. This is mine. I own this, okay? But which is more important? The ownership of these kinds of things or the property that I own? Because personally, I think the property is kind of important. And so if you have a house and it's surrounded by property, it doesn't do you a lot of good if we go, okay, you've got protection in your house, but your property? No. People can just, from the government, wander your property with unfettered access, and they don't need a warrant. That, to me, is a very serious problem. So the clubs now, and their lawsuit, are moving up. They're moving to appeal here. The hunting clubs, represented by the Institute for Justice, will seek to overturn the Russo decision and ask the Pennsylvania Supreme Court to address the pressing question: does the state constitution in Pennsylvania protect citizens from warrantless searches on private land? Warrantless, suspicionless, someone's just wandering around your property. Excuse me, who are you? Oh, I'm a game warden. There's my badge. Get away from me. So Rousseau was wrongly decided, and we're eager to show the Pennsylvania Supreme Court why. Wyndham says, open fields doctrine destroys the point of having private land. Now, you can exclude regular people from it, but the government, no. So it treats fences, gates, posted signs, and everything else you might do to keep your land private as irrelevant. And in turn, it gives the government unfettered power to enter your land, roam around, spy on you, take photos, record videos, take soil samples, ride around in bikes, trucks, and horses, all without a warrant. We're supposed to think that's constitutional. And I don't know about you. I mean, I love horses. I love most animals, but I do not want someone riding a horse on my property. They tend to leave behind souvenirs, and they also, depending on how hard the ground is, can chew up the ground with their hooves. There's a couple places they go mountain biking where they also have parallel horseback riding trails, and occasionally they overlap. And horses can really tear up the trails. And I don't blame them. I mean, that's what horses do. Horses got to walk, right? They got hooves and they got to walk or canter. And I do not want horses on my property without my permission. Presently, there are 6 states, that place state constitutional authority above the open fields doctrine. That is, their state constitution or their courts themselves have ruled and said, our state laws are narrower than the Constitution. Those would be Mississippi, Montana, New York, Oregon, Vermont, and Washington. The Pitch Pine and Punxsutawney arguments before the Pennsylvania Supreme Court should take place this upcoming year, with a decision likely in 2025. Institute for Justice is currently litigating similar open fields cases in Virginia and Tennessee about warrantless intrusions on private land. And quite often those warrantless intrusions are game wardens. And don't get me wrong, I understand that there's laws to be enforced, okay? And a lot of them involve hunting. And so to enforce hunting laws, presumably you got to go where the hunters are. And the hunters are often back in the woods. And I've actually seen on some channel, one of the secondary channels on my cable, a show about game wardens where they follow game wardens around with cameras. And I've seen them walk up to a hunter. Excuse me, sir, can I talk to you? Let me see your license, that kind of thing. And it's not always clear they're doing that on private or public property. I'm not sure. But I've also never seen anybody object on camera and say, excuse me, sir, what are you doing here? But that's always the question, because I know in Michigan, for instance, for deer hunting, there are all kinds of places, public property that you can get to go hunting on, and there are deer everywhere. And so, interesting thing here is that these game warden people are going onto well-marked, fenced-off land, jumping the fences or going through the gates they shouldn't be going through according to the signs on the gates, but saying we can do that because we're government actors, we can do anything we want. So, in an October 2nd Institute press release, Frank Stockdale, president of the Punxsutawney Hunting Club, summarized the private land ownership case. The government has no right to spy on us on our own land without cause. This entire endeavor has been outrageous and needs to end now. So, I often wonder, I get pushback on a lot of cases that I talk about on this show, and I'm always anticipating that someone's going to push back, and then I ask myself, how would they do that? What would the argument be? And I'm not sure what the argument would be to say, oh, Steve, these people are wrong. The government should be allowed to jump a fence with a no trespassing sign on it, go onto private property, poke around, take pictures, sneak around, plant a game camera, and then sneak back out, come back, sneak back in later. I mean, really? What? Who's going to argue in favor of that other than the government? So it's really creepy. And one of the other things, and I do mean that, this is a creepy concept to me, okay? If you've ever owned land and encountered a trespasser, it has a really creepy feeling about it. And I speak from experience. But the other thing I'm also curious about is if they're trying to surveil this property, and they're trying to do it on the down low, as they like to say, do you really want to be hiking around inside a hunting club's private property and blending in really well? Or wouldn't that be a dangerous thing? It seems to me that wouldn't be the safest thing to do. I remember mountain biking on trails that went through state land where they allowed hunting. And when we did that, we wore bright colors on purpose because we didn't want anybody saying, hey, I see movement, shoot. I want to make sure that I stand out. So that's another issue altogether. I'm surprised there hasn't been a conflict there, as I like to say. But again, this story is from Chris Bennett at the Farm Journal and the Institute for Justice itself, doing great work. And as always, I'm going to put a link to them in the description below my video, and highly, highly encourage you to, if nothing else, visit their website. Just bookmark their website and read stories like this to understand what cases are happening around the country that are on the cutting edge of constitutional rights. And the Institute for Justice is one of the warriors out there doing the work that needs to be done on behalf of people like this. So Pennsylvania court rules against gun clubs and private property case, and the Institute says we'll see you on appeal. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Not only do I not know what's going on, I wouldn't know what to do about it if I did.